This is the W2 report with Sanji Himura. Here's Sanji.
Hello, everyone, and welcome to another exciting episode of the W2 Report. I'm your host, Sanji Himura. Today, we take a look at the Ashes of Creation scandal. And before we proceed any further, let's go over the ground rules with Lord Crocosquirrel as always.
Rule number 1, bean up the dick. This includes and is not limited to going after the people we talk about, going after anybody that they've talked to, etc., etc., etc. Rule number 2. If you think for one moment or have questions, please refer to rule number 1.
Please do not go after anybody we may talk about today. That includes people who have previously covered the scandal today. Now, before we proceed any further, we must introduce our guest because it'd be rude not to. I would like to welcome in Mr. Dusky for now. Please explain who you are and why you're so damn cool.
I wouldn't go as far as calling myself cool, but I am the co-lead of the COA project, which is a server emulation software for association.
So before we proceed any further, this is a phrasing choice on my part, but still, we welcome in those of you who are joining us from the FIAS QS server, because he and I became great friends over the last week and a half. Before we proceed any further, let us bring up lawsuit number 1.
There are 2 of these, and we are not going to do both today. I don't think any of us has 5 hours to do that.
Yes, you're right. So this is filed in the District Court of Clark County, Nevada.
That's the area that contains that not only contains but goes a little bit out beyond the limits of Las Vegas, Nevada. Clark County is no joke.
Yes. This is filed by way of Samuel A. Schwartz, Esquire. Who is a lawyer. And Emily D. Anderson, Esquire. Both practiced out of Schwartz PLLC. This is TFE Games Holdings LLC, a Delaware. Now, they're filing this as exempt from arbitration pursuant to ADR Rule 5A1J. But still, let's go over the complaint. Because we have, suffice to say, there's some damning allegations being made by TFE Holding.
They're very hateful, especially to the guys okay. Yeah, we got some really, really, really interesting shit, and this guy here, he's gonna have problems.
Yes.
There is a thing that we that people with brains tend to like to do, and it's not with the money. Do not screw with the money.
Yes. This court possessed plaintiff TFE Games Holdings LLC, a Delaware limited liability company, or TFE or plaintiff, by through its counsel of record Schwartz PLLC, alleges and complains as follows. This court possesses subject matter jurisdiction over this matter pursuant to our NRS subsection 4.370. Because the plaintiff alleges damages in excess of $15,000.
That okay. In excess of $15,000. There's a few things that go with that. A very few things. But if it's over a certain amount, you take it to, you can have it removed to a federal court, which is probably not going to go as well, depending on what it is.
Yes. Venue is proper in this court pursuant to NRS subsections 13.010 and 13.040, in that this is the county in which the obligations of the parties hereto were to be performed or occurred, and a substantial part of the events or omissions giving rise to the claims set forth therein occurred. Basically, what this is saying, for those of you who do not speak legal, basically this is the county.
Who do not speak legalese. We know. We've seen them.
For those of you who do not speak legal, this is the part of the show where, yes, venue is proper because all the actions set forth, all the actions that occurred prior to this lawsuit being filed occurred in this county. The parties. Plaintiff TFE Games Holdings LLC, a Delaware limited liability company, was at all times relevant to the claims therein, harmed by the conduct of residents of Clark County, Nevada. Defendant Steven Sharif, an individual, was at all times relevant to the claims therein, a resident of Clark County, Nevada. Defendant Moore, an individual, was at all times relevant to the claims therein, a resident of Clark County, Nevada. True names and capacities, whether individual, corporate, associate, or otherwise, of defendants named therein as those 1 through 10 inclusive, and road business entities 11 through 20 inclusive, and each of them are unknown to the plaintiff, who therefore sues such defendants by such fictitious names. Plaintiff is informed, believes, and thereon alleges that each of the defendants therein designated therein as a DOE or row business entity are agents, employees, servants, and representatives of the named defendants, or persons and entities answering in concert with the named defendants with respect to the agreement therein pled, who are liable to the plaintiff by reason thereof, and plaintiff basically they're suing a bunch of does, and when we find out who they are, we're going to amend the complaint accordingly.
Well, yeah, they're going to have to. You can't just sue John Doe. John Doe has to have a name and other materials to make any of that work. Really, really, really does.
Factual history. The plaintiff is successor in interest to non-party Intrepid Studios. The plaintiff became successor in interest to Intrepid through a private sale of collateral pursuant to Section 9601 of the Uniform Commercial Code. Through the private sale of collateral, Article 9 sale, the plaintiff foreclosed on Intrepid's assets, including but not limited to, in parentheses it says, collectively Intrepid's assets. Basically, they're claiming a bunch of stuff, and that is where the assets are going to be sold and make TFE Holdings whole again. Oh, wow. Stuff is a legal definition. Well, this is commentary.
Is that actually what they said? They actually put that word in the thing?
No, they didn't.
Things.
Okay. Yeah. Okay. Moving on. Defendant Sharif is the former chief executive officer of Intrepid. Defendant Sharif is a current shareholder of Intrepid. Defendant Moore was an employee or independent contractor for Intrepid. Defendant Moore was also a shareholder of Intrepid. Defendant Moore transferred all or a portion of his shares to Intrepid to Defendant Sharif. 15. Defendant Sharif is in possession of certain Intrepid assets, including but not limited to certain books and records of Intrepid, including all receipts and invoices for the past 3 years and payroll records going back to 2016, as well as the account information. Yeah.
I assume that they were incorporated in 2016?
Let me find out real quick. I don't think so, but you just never know.
Well, no, we need to know when. We do need to know that part.
They were incorporated in May 20th, 2015, according to public records.
Okay, so they start their fiscal year in they begin their fiscal year in May, and as fiscal year 2016, because 2016 is when it ends. So they have to have 10 years, almost 10 years of records.
Mm-hmm.
Or, yeah, well, they have to have, well, if they were incorporated 10 years earlier, they'd have to have 20 years. They're required to store the first 10 years in some place where it can be gotten to. The next 10 years, you've got to have you can store it in a space in the office in case the auditors want to see it. But the top 7 years, you got to be able to put your hands on it within about 15 minutes.
Yes. The problem is, and I really didn't want to go into this at this juncture. However, the problem is
there is problem.
And the board happens to be consistent of Rob Dawson, Jason Calla. I'm going to be we probably should be drinking before we're doing this. Yes.
Yeah.
The board consisted of Rob Dawson, TFE Holdings as the company, Jason Calamentis, I believe I got the name right, and two other people, which we will save for next time, because they're
Okay.
actually named in the Sharif lawsuit. Now, let's continue on. As well as the account information for numerous technology platforms, bank and credit card accounts. Okay, sorry about that, folks. I am currently having internet issues, but we will proceed. We will proceed on as if nothing ever happened.
We also need to be picky choosy about which bits we have to push forward. It's still 14 pages is kind of a lot.
Yeah. Due to this, 16. Due to his position as chief executive officer, defendant Sharif was entrusted with Intrepid's company records. Now, prior to the lawsuit, Mr. Sharif happened to have admitted to step back from the company as CEO, but he's still on as the creative director of Ashes of Creation. So any court that happens to have interpreted the Sharif's resignation as CEO, he had to turn over those records pronto in October. Not when he publicly resigned. Defendant Sharif has refused to turn over company records to the plaintiff despite request. On the January 31st, 2016, Intrepid issued warn notifications to its employees that Intrepid has no alternative than to undertake permanent plant closing within the meaning of the WARN Act by the close of business January 31st, 2026. I'm sorry. Without company records, the plaintiff cannot wind up Intrepid's business and fulfill its obligations under the WARN Act, among other obligations. Now, first claim, brief of fiscatory duty.
Fiduciary.
Fiduciary, yes. I'm sorry.
Yeah. I was trying to figure out which one he's referring to.
It's defendant Sharif owes fiduciary duties to Intrepid as its former chief executive officer.
Yes. As an officer of Intrepid, defendant Sharif was required to perform his duties in good faith in a manner he believed to be in the best interest of the corporation and its shareholders. Now, you got to keep in mind that that there is an alleged amount that was allegedly taken by Sharif. $140 million.
That's a lot.
Yes, that's a lot. But I should have brought this up in another tab, but I don't really care at this point. But I was able to track let me do this. Let me make this bigger. Let me make this bigger for you to read. I was able to track $114 million.
Yeah, which is also kind of a lot.
Yeah. So, back to the complaint. As an officer of intrepid over Intrepid books and records. Defendant Sharif has breached his duties to Intrepid by withholding and refusing to turn over the company records, despite the plaintiff's rightful ownership of such records pursuant to the Article 9 sale. Now, there is a problem with that particular statement. It was requested multiple times that Sharif turn over the company records because it is within their right to request such records.
Yes, it is, and he won't give them up. Mostly because he's got some issues here that he needs to deal with. Like, what the hell is he going to do if they use those records to audit him?
By law, companies are required to turn over the
the records might expose his fraud to the company.
Yes, which is why he doesn't want
it is further alleged that he used company income as personal income on his taxes.
Oh, that might not be. No, that won't go very well at all.
It is further alleged that Sharif used company assets as collateral for a loan with the bank. And above all else, I was able to confirm this morning that Sharif happens to have had a lavish lifestyle on company dime. And even further, Sharif happened to have paid himself and his lover $500,000 a year each, potentially. We do know.
Allegedly.
Okay, so on the allegedly bit, we do know that John was paid $500,000 a year over 10 years. That's $5 million down the drain for a CFO who refused to do any work.
Well, that's $5 million for. That is absolutely 500. That's $5 million for each one. So that's already 10 million.
Mm-hmm.
We do not actually know what Steven was given as compensation package.
Now, we probably should be drunk while we read this. Now, going back to the Kickstarter.
Are you buying the bottle?
Or the sheet.
If you buy the bottle, we can do this drunk all day.
I'll probably buy the bottle. Now, the Kickstarter backers provided $3.2 million.
Well, that's not even enough to pay one guy. Never mind,
both of them. But
never mind him and his wife, whatever.
Mm-hmm. Now, He took out $2.5 million in PPP loans.
Oof. No. No, you don't, dumbass.
Well, he did.
That's not what that was for. Not even remotely.
Steam sales was $3.7 million for December alone.
Should be able to pay for him and his like girl or whatever the hell they were.
Jason provided $12.5 million.
Okay, now we can pay those two.
Yeah, we're up to 21 and a half. We're up to nearly $22 million at this point.
Okay.
Richard Dawson provided $80 million. In cold, hard cash. And that is up to $101 million. Now, if you're familiar with Jason at all, you'll know the name of Tom Alkinson. He provided $2 million. That's $2 million of his life savings.
Ugh. How bad can this guy be? I have to ask.
3 years. That's $852,000 gone. The mansion was worth $8 million. That's $112 million. And TFE Games, by way of Richard Dawson, provided another $2 million.
Now, please note that he contacted when all this shit started going down. He contacted the bank and told them to foreclose the property.
Yep. So, how much income? How did the Kickstarter actually break down?
It's about 30. If I remember right, Kickstarter takes like. God damn it! They take like 30%.
Yes, I was able to. Okay, because the $3.7 million was a public record, became a public record. I was able to track the number of owners that bought the game through Steam for December. 107,000 owners.
Ouch.
Yeah. Now here is where things get a little dicey. He allegedly had four rounds of beta and alpha testing combined.
Reportedly,
yes. According to the Kickstarter. 1,500 people bought into beta 2 access at $40. 1,000 people bought it into beta 2 access for $45. 2,670 bought into beta 2 access at $50. That is so that is 5,170 people bought into beta 2 access. 3,569 bought into beta 1 access. 4,698 bought into alpha 2 access. and 3,285 bought into Alpha One Access. Now, I have a question here.
We have several
Who
questions.
is the dumbasses who managed to buy who managed to drop $10,000 for Alpha One Access? Now, keep in mind, the monetization scheme of the game happens to be subscription based, not buy once and play free forever like Bethesda does.
Like Bethesda does? Wow. No.
Yeah, they did it with Elder Scrolls Online and Fallout 76.
Yeah, no. Fallout 76, I expect to disappear for too much longer.
Now, that broke. So the numbers became $8,606,579.50. The number of owners potentially were 157,166, and Kickstarter took without their fee, mind you, 3. That's a lot of stuff. That's a lot of money.
No kidding.
$8.6 million directly to the company. All because Sharif was greedy. Was greedy, in my opinion.
Well, that's his job.
Now, defendant Sharif received a notice from Valve on January 18th, 2016, that provided Intrepid's secured creditor would be taking $3.5 million receivable, the Steam notice, that the plaintiff was relying on to pay executive officer. Really, it should be creative director. The following day on January 19th, 2026. Now, defendant Sharif breached his duties to Intrepid by authorizing and causing the payment of approximately $17.4 million in unauthorized personal or excessive expenses from January 1st, 2016 to January 31st, 2026. The misappropriations. The misappropriations include, but are not limited to, excessive personal loans to certain shareholders with no documentation or repayment.
Oh, no. One does not do that.
B, direct transfers to shareholders with no stated business purpose.
That's even worse.
Direct transfers to miscellaneous accounts with no stated business purpose.
Again, not great.
Basically, what happened in 33 is Sharif managed to commingle funds,
Okay.
personal and business. D, miscellaneous personal expenses charged to Intrepid's credit cards and or defendant Sharif's personal credit card that was then reimbursed by Intrepid. 34. Defendant Sharif allowed bank accounts owned by Intrepid to be commingled with his personal accounts in the QuickBooks file owned by Intrepid.
Oh, Jesus. No. Don't do that. God, you're an idiot. That guy's was begging to get caught.
Defendant Sharif allowed bank accounts owned by Intrepid to be commingled with defendant Moore's personal bank accounts in the QuickBooks file owned by Intrepid.
Oh, no. No. Bad critter.
Defendant Sharif's misappropriations constituted an intentional misconduct and a knowing violation of the law because they were unlawful, and upon information and belief, Mr. Sharif knew that the misappropriations were unlawful.
Yikes. Yeah, he would have had to.
These misappropriations left Intrepid unable to pay its debts as they became due in ordinary course of business, leading to the Article 9 sale. Defendant Sharif breached his duties by permitting Intrepid's bank accounts to be commingled with his personal accounts and with defendant Moore's personal accounts in Intrepid's QuickBooks file. Upon information and belief, between $10 million and $20 million of the $130 million raised by defendant Sharif for the development of Ashes of Creation was not used by defendant Sharif to develop Ashes of Creation, and was instead used for personal expenses among other unlawful uses.
Mm-hmm. Betcha.
I'm going to actually go back up to 46 here. Defendant Sharif took money out of Intrepid in excess of his salary and earnings without company or board approval in a breach of his duties by paying himself, defendant Moore, friends, and family. They're all going to jail. It's just a question of how long.
Allegedly.
Actually, they may not all be going to jail. If you got somebody that's receiving pretty much salary only, someone that would not otherwise be in the know, they might be asked to return some of it, but I doubt very strongly they'll go to jail for receiving it.
It's technically speaking, they could be charged with receiving stolen property.
They would be charged as an accessory. If they received it, they would be charged as an accessory if they were a part and they were understanding and knowing.
Claim of relief, breach of contract. Financial records of Intrepid identify a certain shareholder loans to defendant Sharif in a approximate total amount of $362,000. Collectively, the Sharif loans. The financial records of Intrepid were maintained in part by defendant Moore, so there may be additional Sharif loans yet to be discovered by the plaintiff.
Yeah, now that guy would be screwed. Defendant Moore? Mm-hmm. Yeah, he's toast. He's done. He's past it.
If all of these allegations are accurate. That's the thing, is these are all claims. These are just claims. We don't actually know.
Well, if found guilty, Sharif and Moore are going to prison.
Well, this is also a civil suit, not a criminal suit. So after all of this, it would then have to go into criminal court.
Yeah, you got me on that one. But see, I have to ask here, why did they do it that way?
Because they're
It
not
seems like
prosecutors. They can't
well-
make the charges. Everything would have to be proven and everything would have to come out. The issue is these guys don't have access to the QuickBooks, and that's part of what they're suing for.
Yes,
Is the
I'm
fact
aware
that
of
the
that.
passwords and everything else, was withheld. And so that's a big part of the entire situation, is the fact that, they can't prove it if they don't have the books to look at in the first place. And even
Well-
if they do have part of the books and everything, like this is more of like a let's get this going. And if they win this, then criminal charges could be considered.
Actually, funnily enough, most of the time you would want to go for criminal charges and then use that to.
Oh no, I
get
agree
off
with
the-
you. I
What?
agree with you, but I'm guessing that the lawyers or something decided that they may not have enough to actually press it, or they didn't want to file police reports. There has to be something behind it, and that is definitely a curious thing that we simply don't know enough. We don't have enough information as to this entire situation. So, ideally, waiting for discovery would be when we would find out all of this information. Is it raining where he is to where his internet keeps dropping?
I
Oh,
don't
here he
know.
is. He's back. There we go.
Sorry about that, folks. I've been having a little spat with the internet company. So,
Oh, there are spats?
yeah. Yeah. Third claim of relief, breach of contract against defendant Moore. Uh, 63, the financial records of Intrepid identify certain shareholder loans to defendant Moore in the amount of $6,680,000, collectively the Moore loans. The financial records of Intrepid were maintained in part by defendant Moore, so there may be yet additional Moore loans yet to be discovered by the plaintiff. And basically, he repeats what was said in the second claim of action. Fourth claim of relief, unjust enrichment against defendant Sharif. Defendant Sharif made or caused to be made certain unauthorized transfers to himself totaling $4,864,000 without documentation or indication that such transfers, whether such transfers were a loan, salary, fee, reimbursements, or shareholder distribution or gift, aka the Sharif transfers. The plaintiff asserts there was agreement between the parties, i.e., Sharif as CEO and Sharif, whether in whatever capacity he received the Sharif transfers, constituting each as a quasi-contract. The Sharif transfers were received and enjoyed by defendant Sharif. Defendant Sharif received a benefit from the Sharif transfers. The plaintiff has a reasonable expectation of repayment from defendant Sharif. Defendant Sharif has not repaid any portion of the Sharif transfers despite receiving and benefiting from the transfers. Defendant Sharif received the transfers from the plaintiff, which is unjust for defendant Sharif to retain without prepayment. To date, defendant Sharif has failed to dispute the total amount of $4.8 million owed by the Sharif transfers. Upon information and belief, defendant Sharif identified Intrepid's investments as revenue in order to obtain the loan to purchase the property.
Oh, no. Now
Defendant
you're talking,
Sharif
now
sold
you're
the
talking
property.
about real property. and that doesn't end well. Ever.
Okay. Defendant Sharif also sold the property for $8.5 million and did not repay Intrepid for the loan, retained the profits from the sale of the property for himself. As such, the plaintiff conferred the benefits on Defendant Sharif. Defendant Sharif appreciated such benefits, and there was an acceptance and retention by Defendant Sharif of such benefits under the circumstances such it would be inequitable for Defendant Sharif to retain the benefits without payment of the value thereof.
Unethical? You're kidding me. Okay.
It has become necessary for the plaintiff to retain the blah, blah, blah. Defendant Sharif made certain unauthorized transfers. Oh, this is the fifth claimant of relief and thus unjust enrichment against Moore. John Moore. Defendant Sharif made certain unauthorized transfers to Moore totaling $5.9 million without documentation or indication that such transfers were a loan, salary, fee, reimbursements, or shareholder distribution or gift, aka the Moore transfers.
More transfers. Yep. More transfers happened than anybody would have liked.
Yep. Defendant Sharif authorized Defendant Moore to be paid for the same services pursuant to two separate contracts. And then we go into blah, 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 blah. Upon information and belief, Defendant Moore is aware that Defendant Sharif had caused Intrepid to take out a loan to purchase the property. Sixth claim of relief, injunctive relief, claim and delivery against Defendant Sharif. The plaintiff is the owner of the company records. Defendant is wrongfully withholding the company records from the plaintiff. Based on plaintiff's knowledge, information, and belief, the defendant refuses to recognize plaintiff's ownership of the company records despite the Article 9 sale. The company records have not taken for a tax assessment or fine pursuant to a statute or seized under execution of it or an attachment of the property against plaintiff, or if so seized that it is by statute exempt from such seizure. The company records are of no value to Defendant Sharif.
Except, of course, to cover up his crimes.
Yes.
If he refuses to hand them over, they can't prove beyond a reasonable doubt that he's
guilty of a crime.
This thing.
Just to interject right quick, there was
Now,
a bit of breaking.
Company
news.
records are invaluable to the plaintiff, as plaintiff cannot continue to
Sanji,
operate. Yes.
Let the man speak.
Sorry about
there's
that.
a bit of breaking news that just happened. TRO was granted against Steven. That's a temporary restraining order. And what that means is that he cannot sell, modify, or change any assets or financials that have been included in this case. So there's some fun information for you right now.
Yeah.
Really? Okay. He may not do the stupid, which is good. Well, he may not do any other stupid. That's more it.
Well, you can't shred the files like Enron did.
Well, no, but he's not supposed to. But contempt of court covers is a completely different beast.
Sorry about the interruption. The company records are invaluable to the plaintiff, as plaintiff cannot continue to operate and protect the value of Intrepid's assets. Conversion, seventh claim of relief. Okay, we got 2 pages to go.
You took mine and then
Yay.
doped it up so that it's now yours. That's a conversion is the crime of, okay, I'm going to steal this and I'm going to keep it. I'm going to keep it, kind of play keep away with it until such
Until I
time.
get my way.
What?
I keep, yeah, you're going to play keep away with it.
Yeah.
Hey, Anubis.
Yo, Nubis.
Is this the Somali that wanted to be deported instead of 40 years in prison?
Yeah, 40 years in federal prison. That's kind of a lot.
No, this is Ashes of Creation, believe it or not.
He's a game that got shut down day after it was done. Okay.
In this case. Okay. The defendant Sharif substantially interfered with the company records owned by the plaintiff by knowingly and intentionally keeping possession of the company records, preventing the plaintiff from having access thereto and refusing to remit the same after the plaintiff's demand. Defendant Sharif wrongfully exerted a distinct and intentional act of dominion over the company records.
Yep. If this is mine, you can't have it. It was like those seagulls from Finding Nemo. Mine, 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 mine.
Defendant Sharif acted in denial or inconsistent with the plaintiff's use and enjoyment of the company records, or in derogation, inclusion, or defiance of the plaintiff's rights or title in the company records.
Moot.
The plaintiff did not consent to Defendant Sharif's conduct relating to the company records. The plaintiff was harmed by Defendant Sharif's conduct related to the company records.
We can that they can prove.
Defendant Sharif's conduct was a substantial factor in causing the plaintiff harm.
Yes.
Defendant Sharif's conduct has caused and continues to directly and approximately cause injury and damage to the plaintiff, including loss of the reasonably expected benefits of its bargain, loss of business opportunities, or other such losses.
Yes. They're also a thing.
Yes. It has become necessary for the plaintiff to blah, blah, blah. Attorney's fees and costs as special damages against Sharif.
Well, actually, funnily enough, if Sharif loses, he's still on the hook for legal fees on both sides.
Yes.
In a civil court.
Yes. Special, but asking for attorney's fees and costs as special damages?
Well,
they
are having to put
that's
together
a new one to me.
Amount of resources, which they claim to have been shorted on, as a result of this this bastard's behavior. Tell me I'm
125.
wrong.
The plaintiff has compelled to retain the services of attorney to prosecute this action on its behalf, and as a result occurred attorney's fees, special damages, as the fees occurred here are a direct, natural, and proximate consequence of Defendant Sharif's wrongful conduct, including but not limited to refusal to turn over the company records.
Uh-huh.
Prayer of relief.
Written, so shall it be.
Prayer of relief. Plaintiff respectfully requests judgment from this court as follows: for general, special, and compensatory damages in excess of $15,000 against the defendants to be in the amount to be proven, for reimbursement of the plaintiff's reasonable attorney's fees and costs occurred therein, for injunctive relief and for pre- and post-judgment interest in amounts awarded at the highest rate permitted by law, and any further relief as the court deems just and proper. Dated February 11th, 2026 by Samuel L. Schwartz.
Wow. Okay.
So, and we happen to have a very special guest. Welcome to the stream, Nefarious. Nephias? I'm sorry for butchering your name.
You're okay.
We just read through TFE versus Steven. What are your thoughts on that?
I have a lot of thoughts, but it's going to be a mess. And Discovery is going to be interesting if it ever makes to Discovery, which I don't think.
All they have to do is win against Steven's
motions to dismiss.
Yeah, motion to dismiss. If he bothers.
Well, they were just granted a TRO, so there's no way that's happening.
Well,
what is a
doesn't
TRO?
mean you can't do
restraining
it.
order?
A temporary restraining order.
Yeah, it's basically a restraining order.
Okay. Issued
It
by...
basically means that they can't sell assets or remove assets or move assets by the court. Yes.
Actually, let me pull up something over here. No, come here. It is Intrepid Studios, TFE versus Sharif. Okay. Now, this is... Now, what you're seeing on your screen right now is an ex parte motion for temporary restraining order pursuant to NRCP 65 B1 or NRS 31. To blah blah blah. Here comes now plaintiff TFE Games Holdings, Denver, blah blah blah.
Delaware.
Okay. Now, here's some names that you probably haven't heard of, Nephias. Hereby move this honorable court for an ex parte temporary restraining order pursuant to laws to prohibit defendant Sharif and his agents, non-parties Timothy Baker, Avery John Cucan, Matthew Rhodes, and Jason Zimmerman, collectively the agents, from continuing to unlawfully withhold from the plaintiff the company records and include but are not limited to the username and passwords for non-party Intrepid Studios. This is a lot of pages, but let's see here. We have technology platforms, bank and credit card accounts, and third-party vendors. Those are the things they want. Those are the things. Actually, technically speaking, can I actually call TFE Holdings Rob for the sake of argument here?
You might as well. It's his holding company. It's him. It's the board.
Anyway, these are the things that Rob wants. Plaintiff hereby moves this honorable court for an ex parte temporary restraining order to compel defendant Sharif to direct his agents to cease withholding company records from the plaintiff immediately, collectively the motion. This motion and the ex parte application for an order shortening time is supported by the following memorandums of points and authorities: the declarations of Robert Dawson, the Dawson Declaration, Teresa Fett, the Fett Declaration, and Emily D. Anderson, Esquire, the Anderson Declaration, and all exhibits attached thereof, and the pleadings on file in this action, and any oral argument that the court may permit. This is the declaration of Robert Dawson in support of the temporary restraining order. I, Robert Dawson, hereby declare as follows. I am over the age of 18 and mentally competent. I'm an authorized representative of the plaintiff. Except otherwise indicated therein, the facts set forth set in this declaration are based on my personal knowledge of the facts of this matter and my review of relevant documents information provided to me or verified by my professional advisors, or my opinion based upon my experience. Where indicated my knowledge is based upon information and belief, I believe them to be true. If called to testify, I could and would do so.
That's just a notarization document stating that it's a sworn statement.
The plaintiff is in urgent need of company records defined therein. TFE believes defendant Sharif may take action to harm the company records if he is notified of this motion. Should any company records be destroyed, such harm would be irreparable, as monetary damages would not recreate any lost data.
This is true.
So you mentioned that the names will be unfamiliar, the new names, anyway, on this updated motion. But there's one name that is familiar, according to sources. Who's that guy? Jason Zimmerman? He's
Yeah,
supposed
Jason
to be
Zimmerman.
the director of IT and had the keys to the former office and everything, which is why
Okay.
I assume he's included in this.
Yeah. Your guess is as good as mine at this point. Plaintiff is in urgent need of the company records. He may harm the company records. TFE has reasonable cause to believe that, at the very minimum, defendant Sharif has possession of credit card accounts and bank accounts included in the company records. The data in these accounts is vulnerable to being deleted or destroyed if the accounts are not maintained by defendant Sharif.
So we don't want you to tell him, because we are not going to be able to get what we need to
Be at danger of destruction, serious harm, concealment, or removal from the state or sale in innocent purchaser. Many of the company records are stored on third-party websites, only accessible with certain usernames and passwords held by defendant Sharif. The plaintiff is the owner of the company records. The company records are wrongfully detained by defendant Sharif. According to the plaintiff's best knowledge, information, and belief, defendant Sharif is withholding the company records to maintain leverage over the plaintiff in the dispute set forth in the complaint.
Uh-oh.
Now, that's actually true, in a sense. I remember reading that Robert and the others, collectively known as the board, basically told So defendant Sharif happens to have been angry at the notion that he's out as CEO, and so he's taken his ball and gone home. Would that be a fair assessment?
Sounds like it. Except he didn't get his vote. He didn't pick up his vote. He picked up everybody else's vote.
Yeah. Defendant Sharif resigned from Intrepid on May 19th, 2026, so he has no commercial use for the company records. Defendant Sharif is aware that the plaintiff is the owner of the company records because Defendant Sharif was the chief executive officer of Intrepid during the private sale of collateral on January 16th, 2026 to the plaintiff, the Article 9 sale. Now, again, I have to hammer this point home. In October of 2025, Sharif made a statement in his lawsuit against Robert and the others that he quit being the CEO of Intrepid in October.
Is stepping back quitting?
No, it is not.
Right. I figured that he just meant he's taking a break or something.
Yeah, I in the light most favorable to Steven here, yeah, stepping back may seem like, okay, I'm taking a leave of absence.
If you're a CEO, you need a formal letter of resignation that needs to be accepted by the board.
But hold on a second. All right, sorry, folks.
Breathe, Sanji.
The plaintiff was a secured party that took possession of security during the Article 9 sale, dated the 17th of February, 2026. Sorry about that, folks. Okay, so pursuant to I declare under perjury, dated the 17th of February, 2026. Robert Dawson. Declaration of Teresa Frett in support of the ex parte motion for a temporary restraining order. Except otherwise indicated therein, the facts set forth in this declaration are based on the agents have been directed multiple times to turn over company records, but they have refused to do so. Upon information and belief, Defendant Sharif also directed his agents and former employees of Intrepid to withhold company records to which each individual has access to from the plaintiff. Dated 17th of February, 2026, Teresa Frett. Declaration of Emily D. Anderson. Not wind up Intrepid's businesses and fulfill its obligations under the Warrant Act upon other obligations. Pursuant to blah, 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 plaintiff tried and failed to serve the defendants with the complaint on February 12th, 14th, and 17th, 2026, and the plaintiff has not provided written or authorized or oral notice of this motion to the defendants, and the court should not require notices to the defendants to ensure the company records are turned over to the plaintiff in good condition. Accordingly, good cause exists to set this matter on shortened time pursuant to for the court to address the motion. The request is made in good faith and not for any improper purpose. Dated 17th of February, 2026. Order shortening time. It is appears to the satisfaction of the court and good cause appearing is hereby ordered based on the declaration of Emily D. Anderson Esquire that the motion for a temporary restraining order pursuant to law
Basically, it was just expedited.
10:00 a.m. on Department 13 of the 8th Judicial District Court. Now, the judge will go over his arguments here. Go over the arguments here. Because as far as I understand the situation, the complaint was not served to Steven Sharif happens to have been evading service of the lawsuit. Is that a fair assessment at this point?
Sounds like it.
Yeah, he goes over here. Defendant Sharif is the former executive officer of Intrepid. Defendant Sharif is in possession of certain Intrepid assets, including but not limited to the company records, including all receipts and payroll going back the past 3 years, and payroll records going back to 2016, as well as the account information for numerous technology platforms, bank and credit card accounts, and blah, 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 the company records. Defendant Sharif has refused to turn over the company records to the plaintiff despite requests. On February 31st, 2026, the Warrant Act was issued. Defendant directed agents multiple times to turn over the company records, but they refused to do so. He cites the FET declaration at paragraph 4. Upon information and belief, Defendant Sharif also directed his agents, former employees of Intrepid, to withhold company records to each individual that has access from the plaintiff. Paragraph 5. On 2 separate occasions since the Article 9 sale, defendant agents have refused to turn over certain information and take certain actions that the agents until this Defendant Sharif directed them to do so. Paragraph 6. Once the defendant directed his agents to accomplish a task that I have already requested is completed immediately. Paragraph 6. The court may issue an ex parte temporary restraining order if certain requirements of the law are satisfied, specifically in pertinent part. Movant's attorney certifies in writing any efforts made to give notice and the reasons why it should not be required.
It should not be required. That's bullshit.
Furthermore, the temporary restraining order itself must state that the date and hour it was issued, describe the injury, and state why is it irreparable. State why the order was issued without notice
Without
and
the
be
presence of the defendant, if they can even find his ass.
Yeah. Legal argument: a temporary restraining order is warranted here in order to order Defendant Sharif to immediately return the company records to the plaintiff, which I believe Sheriff did not do yet.
Sharif,
As far as I understand the situation. You gotta come right now. He fell. 1 second. I have an emergency.
okay, so Sanji is busy with an emergency. What do you guys think about this? What are you?
to me. A nice documentary, I think.
Yeah, agreed. No joke.
Oh my god.
I mean, so a TRO is a common thing that's going to be put out in something like this. The expediting of it is a moderate surprise. That's not something that's granted all the time.
But it is granted often
You
enough.
do have to. Yeah, it's granted often enough, but I'm not saying all the time. The fact that he was able to get one granted and expedited means that it's likely that he has evidence to the fact that Steven may be capable of deleting or modifying things that could cause issues with court proceedings, or Mr. Zimmerman or whomever else is involved and listed in this specific TRO. So there's a lot to unpack here. But again, it's one of those things that we don't have enough information to really say that much about it.
Also, TROs are usually judged based on whatever TROs and well, anyway, it's not with TROs. It's not necessarily the injured party that they're talking about.
Well, the ex parte means it's one party.
Yes, it's one
What
party.
that means is, yeah.
But the judgment standard, or at least in most of the U.S., is that you have to take the elements
How that, folks?
as if at the best possible interpretation for the, for whoever it was that fired, for the party that was the non-filing party. There you go. Sorry, I lost words.
All right, sorry about that, folks. I just got back. Here, the TFE believes that defendant Sharif may take action to harm the company records if he is notified of the motion. Should any company records be destroyed, such harm would be irreparable, as monetary damages would not recreate any lost data. Dawson Declaration at paragraph 5. TFE has reasonable cause to believe that, at very minimum, defendant Sharif has possession of credit card accounts and bank accounts. Moreover, the data in these accounts are vulnerable to being deleted or destroyed if the accounts are not being maintained by defendant Sharif. The data in these accounts could also be lost permanently if the accounts are not paid for by the plaintiff. Further, TFE is a secured party pursuant to law. Indeed, the TFE took ownership of the company records through an Article 9 sale. So it is the definition of a secured party taking possession of collateral which it is foreclosed. See Exhibit 1, the Article 9 sale documentation. Due to the realities of technology, many of the company records are stored on third-party websites with certain username and passwords held by defendant Sharif. As such, ownership of the books and records necessarily includes the passwords required to access those records. As a secured party taking possession of its property, the court should decline to require a bond pursuant to law. And defendant Sharif has failed to explain why he continues to withhold the company records. Indeed, he has not challenged the plaintiff's ownership of the company records, nor... Yes?
No. Carry on.
Nor did he take any action as chief executive officer of Intrepid to challenge the Article 9 sale. As such, defendant Sharif is likely withholding the company records to maintain leverage over the plaintiff in the dispute set forth in the complaint. Upon information and belief, defendant Sharif also directed his agents and former employees of Intrepid to withhold the company records, to which each individual has access from the plaintiff. The FET declaration at paragraph 5. Therefore, the court should issue an injunctive relief in form of a temporary restraining order to ensure that the plaintiff has the company records that include but are not limited to usernames and passwords, blah, blah, blah. Therefore, the court should this is the proposed order. Therefore, the court should issue injunctive relief in the form of a temporary restraining order to ensure the company records are returned. Exhibit 1. And these are all the applications that are alleged to have been held by Sharif. Blah, 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 blah. Exhibit 2. These are all the accounts that have been held by Sharif. Exhibit 3. These are all the vendors involved. Exhibit 4. And this is the Article 9 sale, I believe. Am I right?
I can't tell. Might be.
Blah blah blah. Certificate of service. Yeah. Administration by Susan Roman. And this is some stuff here. Okay, so that's pretty much it for today, I think. But while I okay. Okay, so we basically got some time to kill, I think.
Not based on our usual.
No, but we do have some guests involved.
Sure, go for it.
All right,
We got one.
So should we bring up Steven versus Rob while I'm thinking about it?
I think you should leave that for a separate episode because that'll be double the time.
It's just that, yeah, all of this is basically insane.
Oh yeah, we know. We know all about that.
So, let's bring up Steven versus Rob while I'm thinking about it. This is brought to us by Conte Cilia from Withers Bergman LLP and Jordan W. Garman, Act Pro Vice in forthcoming in New York. Defendants, attorneys for Plaintiff Sharif as an individual or derivatively on behalf of Intrepid Studios Incorporated. Now, Steven Sharif as an individual, derivatively or on behalf of Intrepid Studios, versus Robert Dawson, Ryan Ogan, Teresa Fett, Aaron Bartels, and TFE Games Holding. Defendants, and Intrepid Studios is the nominal defendant. I am honestly there is some stuff that we can do. The board defendants, he grouped them as the board defendants, and TFE collectively the defendants. Okay. We're going to have some fireworks right off the bat.
Oh boy.
This lawsuit seeks to stop Intrepid's rogue board of directors from intentionally destroying the company, including through layoffs or nearly its entire workforce, through manufactured crisis, and through bad faith foreclosures on secured loans. The board defendants intentionally sabotage Intrepid to steal its assets, including its most valuable assets, its intellectual property, and even trade secrets. That intellectual property was developed under the leadership of plaintiff Steven Sharif, a shareholder in Intrepid, its visionary founder and creator of the MMORPG Ashes of Creation. Okay, whatever.
I sense a great disturbance in the force, like somebody turned into an idiot, and suddenly it started yapping.
Yes. Plaintiff has dedicated more than a decade developing Ashes of Creation, including its world, lore, gameplay systems, software architecture, and proprietary development tools. He thinks that's bullshit.
Why would it not be bullshit?
Who knows at this point?
I don't know. What I do know is that people are being stupid. It's just a thing that they do.
The gaming community has been anxiously awaiting the full release of Ashes of Creation for years. Defendants well understood that success or failure of Ashes of Creation would be exceedingly public and personal to the plaintiff. They also understood that its success would be exceedingly profitable. The board defendants took steps to ensure they alone profited from that success. Beginning in 2024, defendant Robert Dawson's Intrepid principal lender embarked on a campaign to extort control of Intrepid from the plaintiff and ultimately strip Intrepid of its assets, including its groundbreaking intellectual property and trade secrets for Dawson's own use and financial gain. Through repeated threats to withhold funding for payroll, to shut Intrepid down, and to financially ruin the plaintiff, or even to physically harm the plaintiff.
Physically harm? You better be able to back that shit up. Ooh, do not. Oh. Unless you have some sort of verifiable threat, you
I guess we can take a break from here right now.
We probably should, since we're
so with that out of the way,
2 hours mark.
Let me say, the more you know, and knowing is half the battle. This is going to be a complete mess. I feel. So,
and this here is about the time that paper starts flying everywhere.
Yes. So we will resume. I think next Thursday we are going to resume the Intrepid lawsuits.
To see what updates they made.
Yes, that'd be fun. Tuesday we will go back to the Secrets of the DEI playbook for those who are interested. We have had 6 video. Actually, no. I think we may do news without the echo chamber.
That might be
Tuesday.
better.
Yeah, that might be better. News without the echo chamber on Tuesday. So, with that out of the way, I have been Sanji Himura. Thank you all for watching. And beware, the taxman cometh.
Hello, folks. This is Morgan Freeman. This concludes our broadcast day. I'm Logan Freeman. Good night.